Miss Bernard,
Here.
Mr. Furman,
Here.
Dr. Guadalupe,
Here.
Dr. Hans,
Here.
Mr. Landsman, Mr. Lindemeyer,
Here.
Miss Namie Dyer,
Here.
Miss Newman, Dr. Taub,
Here.
Mr. Torres,
Here.
Miss Summers,
Here.
Mr. Kemp.
Here. Okay, well, thank you, Sheila. This is, as Judy has said, my inaugural meeting committee facilitator of the collection of the whole. I would like to start today with a moment of silence for George Floyd, and I would like Sheila to do set the clock. We'll stop now for 8 minutes and 46 seconds to pay our respects. Okay, are we back, Sheila?
Yeah. You're back.
Okay, thank you. I think that was important that we took that time and remembered what's important here today. Going forward with the agenda, we have public time for public comment. Christine or someone, do you want to report out on if we've received any comments?
Yeah, this is Suzanne, and we do not have any public comment at this time. The communications team will continue to monitor the chat and the comments forum to see if there's any comment for the last part of the agenda.
Okay. Anya, do you want to give us a report, Anya, Nicole, and Diana, on COVID-19, please?
Sure. Good afternoon. I had to unmute myself there. So our COVID update is going to be fairly brief, but we did turn in the department requested stabilization plan. So we have not heard back from that other than that they have received it, but we do expect to have that approved shortly with, I would expect, no changes. But if there's any changes, we'll make those modifications. But they were pretty aware of what we were doing and how we were handling everything, and very much in support of what we were doing. So Nicole, do you want to go on to any of the programmatic things?
Yep. Good evening, everybody. We have no staff currently using the loss or respite home. It's back to being a respite home for the people that we support. We do, however, continue to allow hotel room stays to be an option if staff were feeling sick or not feeling safe to return home, though we haven't had any requests for staffing for hotels since May 11th. We're very happy to say that the last person we served was discharged healthy from Pontiac General Hospital. So we no longer have anyone using that as a quarantine space, though we do intend to maintain that contract should that be needed again. We continue with ongoing weekly meetings with our residential and vocational providers. And last week we invited our core provider agencies there just to encourage and facilitate ongoing communication as the state starts to reopen and vocational service providers start to reopen as well. So I think Diana is going to talk some technology and some OCHN reopening.
Thanks, Nicole. Good evening, everyone. Or I guess it's actually late afternoon. So one of the things that we've talked about is that OCHN has procured about 150 tablets to get into the hands of people that we serve to be able to use for telemedicine. We are working with our providers on identifying the process to get those in the hands of people that we serve, and we will continue to give the board updates on where we are with that. As for the building reopening, we did not adjust the dates for reopening, even though the governor lifted the stay-at-home order. We kept everything as is to be able to give us the opportunity to be able to get the buildings and our spaces ready and cleaned and PPE in place. So both Troy and our spaces in the RCC are being cleaned this week, having a deep cleaning. Leadership will return to the office for those that are returning. They can return starting next Monday. And we are still allowing as many people as possible to telecommute. The following week, we will start having staff who will be reporting to the office, either coming in on Monday, Wednesday, or Tuesday, Thursday. They will start to come in that following week. We've continued to have conversations with tenants. We have developed a playbook. We will be doing self-screening. So before employees who are coming into the office come, they will complete a screening form and take their temperature. We will have PPE issued to our staff. So everybody will get mask, hand sanitizer. We will have wipes and hand sanitizer available throughout the building. And, you know, I think one of the things that we are really trying to make sure that we're doing is that we're remaining flexible during this time, since we know that we could have another outbreak, or that as information changes for COVID. So everything that we're doing, we're trying to keep flexible for those reasons, as well as knowing that we will have a new CEO starting in the next few weeks. That is all I have. So are there any questions?
Yes, this is Jonathan. Hi.
Hello, Jonathan.
How are you?
I'm doing well, thank you.
Good. I know that in a number of buildings and a number of other healthcare facilities,
Mhm.
they're adopting social distancing in hallways, making stairwells one ways, and putting things not only in the regular hallways, of spacing stickers and stuff, so that people get much better at recognizing what is 6 feet, 2 meters, whatever, but
Yep.
also identifying circles and spots in elevators and going one-way routes on stairs, which I guess if there's a fire, that becomes immaterial. Everyone's going downstairs on all stairwells. But are you guys looking at those kinds of things as well within our within our building? It's not new anymore, but within our building. Thank
Yeah,
you.
that's a great question, Jonathan. All of those things actually that you listed there. So we have 2 stairways in Troy. One will be up, one will be down. We are limiting the number of people who can be in elevators. Additionally, we will be having like one-way traffic, as you were talking about. So as we're going through cubes and other areas of the building where it makes sense, we will be laying out and having people being able to walk through those.
Okay. Same thing goes with the atriums on the upper floors. Is that going to be like all clockwise or all counterclockwise?
I don't know if we have decided on that one. That is something I have to check in with Mark on because he is the one who is drawing those out. I will make a note of that.
Yeah, that's what they're doing to our office buildings. So,
Yeah.
and at Providence. So that's why I was asking.
Yep. Good question. There's a lot of things with this that you never would have thought of that you need to take into account. Are there any other questions?
Doesn't look like we have anything, Diana.
Sorry, I do have one question.
Okay.
For Diana. Since we're talking about, well, I don't know if you'd be the one to answer this, but when do we anticipate having meetings in the office again? Like board meetings and other meetings, or has that been discussed?
So we have started thinking about that, and I have reached out to Mark Dugood because we would have to change the board table and other aspects won't be able to stay the way that they are. So there's a lot of information in what our plan is, Malakaya, is we're going to put together what it would look like and what our recommendation would be for how the board would be seated, who would be able to be seated from the public, how many people would we be able to accommodate, and what would the process be, and present that to the board so that you guys as a board can make a decision on what you want to do with the meetings.
So there's not a timing on that, right, Diana? Not yet.
We don't have a timing. We have started those conversations, most certainly.
Okay.
This is Anya. I just want to add to that, just to say that, as of right now, the governor's order is still to work remotely if you can. So we want to make sure that we're being safe for everybody and planning appropriately. So given that this seems to be working pretty well, we were hoping to have a little more time to plan well and make sure that we have everybody the right distance apart and all of those things in place before we start really talking about a date. So unless the board feels otherwise, that would be our preference, to have the plan fully vetted before and present it to you before we really pick a date.
Yeah, because there are things to also add on to what Anya was saying. Our cameras right now, that we use to be able to record the board meetings so people in the public can either watch them live or be able to go back and watch them. The cameras are not set up in that room to be able to, they're set up to specifically accommodate the current board setup. So there's a lot of different aspects of that we would need to work through, as well as, are we taking temperatures? What kind of screenings are we doing? So as Anya said, it's going to take some time to be able to put together what we would want to be a thoughtful plan for the board.
Pat, this is Jonathan.
Yeah.
I would be inclined to hold off and continue with our Open Meetings Act virtually until that is, what's the right word? Until that's revoked by the governor, if it is, just because I am trying to still maintain my self-quarantining.
Yep. I agree, unless it's an issue with someone.
I guess this is Malchiah, Pat. I guess the reason I brought it up is because I'd like for the board to be a little bit more involved instead of just developing a plan and giving it to us. I'm not sure how that would work, but I just think we should have a little more input on it since it's our meeting. That's my thought.
So we're happy to take any of your thoughts and considerations in. I guess we didn't think that the plan would be finalized before when we presented it to you, more so that these are our thoughts, these are the precautions we as the employer have to take for everyone in the space. So we're happy to have your input.
Okay, that's again, this Malchiah. I just think it would be things that you may not think of that would be concerns to us.
Yep.
And if we could have input along the way, I think it would be better. That's my thought.
Okay, so do you want to go ahead and send us anything you guys think of as we're starting to put that together? What are you thinking?
Well, I'm thinking of whatever you have in mind right now, if you could send that to us right now so we could review it and then weigh in on it. Because you have had the most interaction with the governor's, with the governor's recommendations. Some of us know a little bit more than others, so it's maybe things we don't think about. But I just feel we need to be, or my thought is it would be helpful for us to be involved with the planning stages of it before you have come up with the final.
Okay, so certainly we'll send that out for review prior to it being presented.
Thank you.
Yep. And Jonathan here, I would just say that we probably want you guys to go through a couple of weeks of dry run with operational execution. And so that the concept is now no longer just a concept, and then we could see if there's other things that we think we need to have as well. I'm just thinking we've got a portion of the board that's, I would say, in the at-risk groups.
Yeah, and so that's really what we're doing now with leadership coming back first. I've actually gone back to the building a couple days a week now just to, again, start that kind of just testing things out. We've got leadership coming back next week. And then, as Diana mentioned, the additional staff. So that's the whole point of all of that, slow kind of start to add people so that we can check things out. And we can share with you what we've got when we've got a document that's put together.
Okay, I think John Paul had a comment.
Yeah, John Paul here. I would agree with Malchiah to the respect that if we would be allowed some input on that, and the thought of maybe some kind of hybrid version of coming back as a board, whether it be some board members being allowed to be physically present and others, operating virtually. To some respect, but I'm okay either way. I just would like to, obviously safety is first, and we want to make sure that we're following all guidelines. But any input that the board could give with regard to it would be appreciated. Thank you.
So I think that if someone has thoughts, please pass them on, probably to Anya, and copy Judy, so the board can catch up on it. And thoughts about how to do this. I think also our next agenda item with Andy is probably going to address maybe at this stage, what we can do and what we can't do as far as open meetings. Can we do virtual? Can we do a hybrid? I don't know. Andy, if you can address that maybe while we're going through your part of the presentation, that would probably be helpful.
Yeah, absolutely. Excuse me.
Any more comments or thoughts on the COVID-19 and the opening of the building? Okay, why don't we move over to the next agenda item with Andy. He's going to go through the Open Meetings Act 101. There's quite a few charts. Andy's going to hit the highlights for us. I think the newer people like myself have climbed through it since we received it recently. And so if you can make sure, Andy, that we hit the highlights and just, move right along, it would be very helpful.
Absolutely. Again, Andrew Breggy here. This is Open Meetings Act 101. This is kind of the training that we generally put together for boards. And I know that some of you have sat through a very similar presentation I did back in July, I think, or August of 18. And I know before that, Chris Johnson had done it, I think, in 16 with you guys. So I'm gonna, I guess I say next slide to whoever's in control. All right. So as was indicated, there are 85 total slides here, but we're going to try to skip through a lot of them, which is why you were given it in advance. But brief overview, the Open Meetings Act is something that requires all decisions of public bodies to be made at meetings that are open to the public, with very few exceptions. The Open Meetings Act is something that was passed in 1976 as part of a wave across the country of things called sunshine laws. As some of you may recall, we had a president in the early 70s who apparently got in some trouble because of a lack of openness, something to do with a hotel. And in direct response to the Nixon administration, these sunshine laws, so-called, so that they could spread sunshine on the operation of government, were passed around the country. Those were things like the Freedom of Information Act and, as we care about today, the Open Meetings Act. Next slide. It promotes open government openness of governmental action by providing public access and input into the decision making. That's why we have to have these open meetings. We have public comment, and we have to allow all of the public to have full access to it. Next slide. So what is a public body? Well, the statute has a very long and convoluted definition of what a public body is, but we can skip through that and go to the next slide, because we know that OCHN, as a mental health authority established through the Mental Health Code, already is duty bound by the statute, particularly Section 9 of 330-1205, that says we are a public body and we are bound to follow the Open Meetings Act and all of its rules and obligations. So we don't even need to worry about whether or not OCHN's board in itself qualifies under the convoluted definition, because our authorizing statute says we are. Next slide. But one of the things that we do need to think about is that sub-quorum committees that deliberate towards or render decisions also can constitute public bodies. So if you have a sub-quorum committee that has the authority to make decisions, that sub-quorum committee is itself a separate public body that needs to comply with the Open Meetings Act. Next slide. The Open Meetings Act does not apply to committees that adopt non-policy making resolutions. So if you have a sub-quorum whose only purpose is to make resolutions saying, employee of the month, but it doesn't include any other benefit than just making a resolution saying that's the employee of the month, that's not something that's going to be subject to the Open Meetings Act. Purely advisory committees that are less than a quorum, that do not make any type of decision, but are purely advisory, do not qualify as a public body. And it also does not apply to social or chance gatherings, so long as those are not designed to avoid the Open Meetings Act, which means it's okay to meet socially outside of board business, but you got to make sure you are not discussing board business at these social and chance gatherings. Next slide. So what is a meeting? Meeting is a quorum where at least a quorum of the board is present and the purpose is to deliberate towards rendering a decision. Next. Quorum is the minimum number required to do business. For us, for the full board, that's 7. You have to have at least 7 present, and if you do have 7 present, then that's a board meeting. Same thing with a sub-quorum. If it's a 5-member, you need 3. If it's a 3-member, you need 2. Next. We were talking about video and telephonic attendance and whether or not we should be continuing with this. Well, obviously, before the current pandemic, it was allowed that video and telephonic attendance could be used to have board members present for meetings. In order to do so, the board members need to actually be able to make sure they have uninterrupted communication so that you are always able to fully hear and interact. But that was before we've got the current orders that allow the entire meeting to take place electronically. But before this, it was still okay for board members to attend board meetings electronically. Now, your own internal rules may have different requirements to that, but that doesn't mean that having an internal rule that disallowed it would mean that you're violating the Open Meetings Act. Next slide. So about 8 years ago, the state legislature tried to eliminate the video and telephonic attendance, but that bill was eventually shot down, and they tried it again for the next couple years. The first time that we had any major change, though, next slide, is in 2018, where the legislature passed an amendment that specifically allows, or rather requires, a board to issue a policy for accommodation of members of the military that are going to be absent. So it acknowledges that there are going to be specific times when people can't be present due to military obligations, and so we are required to set up policies and procedures to ensure they're still able to participate even if they are not able to be physically present. Next. So one of the practice tips for when we are able to meet back in person, if you are going to still allow, under your own rules, the video and telephonic attendance, one of the things that we recommend is that make sure all of your meeting votes are done by roll call, so then you can actually confirm the vote of those people that attended telephonically, and we will know, or we can at least ensure through the minutes that they were able to fully participate. Next. And as we've all talked about, and as we obviously all know, we are currently doing all of our meetings electronically, but this does not eliminate our obligations to allow all persons to participate in meetings of a public body held electronically. So we can't kick people out of a meeting just because we don't like their screen name or things like that. The public still has to be given the opportunity to participate. And as long as these executive orders remain in effect, we are still going to have to comply with that. Now, when we do start meeting in person again, that, having it as a hybrid situation, there's probably going to be a big push that people are going to want to still do that and participate electronically. At this stage, we don't know if there's going to be a proposed amendment to the Open Meetings Act, but I think as it currently stands, it's going to be up to each board on how their policies are going to be as to whether or not they still want to allow participation, i.e. the public comment coming from people that are not physically present at the meetings. But as of right now, we're not sure where the legislature is going to go, if they go anywhere on that. So next. So what is deliberating? That's not something defined in the statute, but the courts have have looked at it and basically said deliberating is when you're considering, discussing, and exchanging your views. When you're debating something, that's when you're deliberating. Next. So back in 1976, when this was passed, some of these things, like what we're doing now, would have been science fiction. Next. Next slide. So computers, cell phones, all of those things did not exist. You can go next. Back when the statute was passed. So deliberating can be done electronically, and this is something that Pat kind of mentioned we could hit on here. If you are exchanging emails and texts, that can be considered a violation of the Open Meetings Act. The reply all button is something that is problematic. So when what was being discussed earlier, making sure the board gets input on things, when the proposed plan gets emailed, make sure everybody's not hitting reply all, or as a practice tip, it can be sent out as a blind CC to everyone so that the reply can only go to one person who sent it out, and then maybe all of those points can be gathered and then presented for the full board to discuss, so that you're not engaging in the deliberation via email, because obviously if you're replying all and discussing things via email, you're not doing it at an open meeting. Next. Another issue is that sometimes people text and email during board meetings. And while you may not be talking about what's the subject of the meeting, though that information may still end up being subject to FOIA, and it could cause further problems down the road. Next. Social media is another one that has been a more recent issue. When we have board members posting or championing great ideas on their Facebook page or on Twitter, and then we have other board members commenting on it, and then it gets into a discussion taking place in a comment thread on Facebook, well, that's not an open meeting, and that could be considered potentially deliberating. So you want to try to avoid engaging in things like that. Next. I'll skip over this example, or I'll just go over it very quickly. What happened in a particular city down in Washtenaw County a few years ago, so a FOIA request was made for information related to a particular vote. Included in the response were email exchanges that are time-stamped. Those email exchanges, the FOIA requester, who was a investigative reporter, was able to look at the timestamp and realize that it lined up with times that meetings were supposed to be going on. So it showed that these board members were sending emails during board meetings. Now, the emails didn't have anything to do with what was actually going on, but they did reveal that there were very childish things, crude remarks being sent amongst the various council members, and it ended up that it was during an election year, and one of those board members, city council members, lost his seat in the election because of those emails. So you want to make sure you're not doing that kind of thing. So next. So if it has anything to do with the issues you guys are considering, you should discuss it at an open meeting and not be exchanging emails amongst board on things like this. Next. And we can move forward again. Next. So what are the procedural requirements? First off, notice, and I'm going to speed through the notice thing. So next. All public bodies must provide notice of their meetings. Next. The notice must contain the name of the public body, the telephone number, and your address, and they must be posted at your principal office. Any other locations you think are appropriate, can do it on cable TV. You can post it at the county office. Next. For all of your regular meetings, you must post the notice within 10 days after your organizational meeting, for that's either the calendar or fiscal year. Next. If there's any changes You need to post the new schedule with all the changes within 3 days after the meeting. Next. If you have a rescheduled regular or special meeting, the public notice stating the date and time must be posted at least 18 hours before that meeting in a prominent and conspicuous place. And next, that's a very long mouthful from the statute that says on your website. Next. So if you are going to amend anything or repost the meeting, you have to put it on your website. Next. If a meeting is recessed for more than 36 hours, you must post a new notice because apparently after 36 hours, they consider that no longer a recess, but just an adjournment and a new meeting. So if you recess for more than 36 hours, you need to post as a new meeting. Next. Emergency meetings are not something we need to be overly concerned with, so I'll leave these slides to your review. So next. Next. One of the things about notices is that any member of the public can subscribe to notices for a yearly fee. So you can, if someone sends a FOIA request and says, I want to be given a subscription to your notices, you have to send them a notice every month whenever you have a new meeting. And they must be, if requested, made free of charge to any radio or television station within the state or any newspaper. Next. So now we can talk about what happens at the meetings. Next. And again, remember, you can only have a meeting if you've given proper notice. Next. All meetings shall be open to the public and shall be held in a place available to the general public. As of right now, available to the general public is the link that everyone can access to get to these virtual meetings. Once we are back in person, place generally available to the public will be like our normal big boardroom meeting where we have all of our other meetings. It needs to be someplace. Can't hold it in Pat, we're not going to hold the meeting in your basement. We need to have it a place that's going to be available for everyone. So next. Anyone should be permitted to enter the meeting. Everyone that attends the meeting has the right to tape record or videotape. They can broadcast it. Even though we are broadcasting on our own, people that attend have the right to do that, and they don't have to get prior permission to do so. Though we are able to establish certain rules, like they can't block our cameras in order for them to set up their recording. Basically, you can section off an area where videotaping can be done as long as that's part of your regular procedures and you're not singling somebody out. Next. Next. All decisions of a public body must be made at a meeting open to the public. Next. Again, the deliberations of a quorum must take place unless it's one of the exceptions that we're going to talk about in a little bit. Next. A person does not need to provide their name or other information as a condition to attend a meeting. So you can't require people to register or sign an attendance list. Now you can pass it around, and if they want to, they are free to. They do not have to. So you can't ask them to leave if they refuse to provide their name. Next. Everyone that attends a meeting shall be permitted to address the public body. That's what we call public comment. We can only limit public comment if we have established rules that limit public comment. Like we have the 5-minute rule. One of the things about public comment is that you cannot have a rule that limits the total amount of public comment available for everyone, because by doing so, you could be preventing an individual from making comment. So for example, you can't have a 1 hour total limitation on public comment, because if everyone takes up their full 5-minute allotment, you would only be allowing up to 12 people to comment. And if there's somebody that's not allowed to comment because that 1 hour is up, you would be violating the Open Meetings Act. So you can't have an overall time limit. Just as an example, I live in Grand Ledge, and the superintendent of our school system last week said some insensitive things on Facebook, to put it lightly. And there was a board meeting, a special board meeting held just this past Friday. 600 people virtually attended, and all of them wanted to make public comment. And that board meeting lasted, I think they got done around 8 o'clock. And they started at 10 o'clock in the morning. So everyone gets to have their say. Next.
Andy?
Yes,
Sarah Guadalupe. Can I ask you one quick question on the
absolutely.
public comment? So tomorrow we have our contract development negotiation for the new CEO.
Mhm.
So does that mean we have to put in a public comment section for that as well? It is public. I keep hearing feedback. I'm sorry.
So that committee is working towards making a decision. So it's noticed up as a regular meeting, correct?
I do believe so. Sheila, is that how we have it?
Yes, that's correct.
Yeah. So anytime there's a meeting and the meeting is of what could be considered a public body, a group of the board working towards making a decision, then you have to follow all of the rules, which would include public comment.
Okay.
Now, one of the things about public comment, and I know this has come up a lot now that it seems that most people or everybody's attending everything virtually, that rule about people not having to provide their names in order to attend isn't the same as requiring someone to provide their name in order to make a public comment. If you already have a policy that says you need to give your name if you're going to make a comment, that can be okay. And if they refuse to provide their name, then they don't have to be able to make a comment. And the purposes behind that are, and we'll get into this later on, we're required to keep a set of minutes that records everything that happened during an open meeting. So if someone is refusing to provide their name, which happens quite a bit on these virtual meetings when we are being bombed, so to speak, by the people that are just coming on to shout obscenities. If they're not willing to provide their name, you don't have to allow them to make the comment.
Andrew,
Next. Yes.
this is Jonathan Landsman. I know that some public organizations only have a single public comment at the beginning or at the end of their sessions. I know we've had a practice of doing them at both.
Mm-hmm.
I think it's a really good practice because it helps share transparency, but is that a requirement?
No, so the requirement is only that you have at least one. And so then that becomes a policy, an internal policy decision. But having it at both ends does further the promotion of interaction and accountability and openness. One of the practice points a number of the municipalities I work with do is they'll have maybe at the end of the meeting public comment open to just all broad public comment, but then the early first section of public comment will be public comment, and they request that it's limited only to agenda items. But there's no requirement for that. As long as you have at least one public comment period where anyone can get up and speak about whatever they want, then you're fine. Now, one of the things you can do is if you are in a situation where you've got 600 people getting ready to speak, you can request, and as long as it's part of your policy, that if people are simply going to repeat the same comments, that they designate one person to speak on behalf of the group, and then that can sometimes encourage the limitation of repetitive comments, but you can't actually prevent people from saying things. People cannot be excluded from a meeting unless they breach the peace during the meeting. It's a pretty high standard, and it's not one that is going to be met most of the time. Someone's going to actually have to get up and start a fight or do something, shout fire in the crowded theater, so to speak, in order to need to be removed from a meeting. So for the most part, you're not going to be able to kick people out just because you don't like things that they're doing or saying at the meeting. Now, if they are continuously disrupting, and it's outside of public comment, that could potentially be a problem because now they're interfering with your ability to conduct business. So that could potentially be it. But for the most part, you're not going to be able to kick people out. Next. I will leave this to you to view on your own if you are interested, but it's a video from the Wichita, Kansas School Board. And it's a relatively long video, but the issue that's presented there is within the first 7 minutes. The board chair allows public comment. A member of the public gets up during her 3 minutes of public comment and starts talking, and the board chair consistently interrupts her and uses up part of her time by interrupting her and cutting her off. And that's a problem because in a federal case in Michigan, we had the judge say that that's a jury question as to whether or not a board member intentionally violates the Open Meetings Act when you interrupt and prevent a person from using up their time and making their public comments. So feel free to watch that video on your own, but for purposes of speeding through, we're gonna skip that. Next. So there are 10 exceptions to whether or not the Open Meetings Act applies, and for the most part, these don't really apply to you. Next, the only exceptions that would potentially apply are what we've already talked about. Non-policy making committee, subcommittee, or the meeting or social gathering, the chance gathering, where you are not trying to intentionally avoid the act and you're not deliberating. So those would be the only real exceptions that apply to us. Next, part that everybody always is interested in after we've spent all this time talking about being open is when can we be closed. All the closed session exceptions to the Open Meetings Act are not mandatory. That means you are never required to go into a closed session. All the statute does is it provides you an opportunity to, if you want to, and you meet the certain criteria that these exceptions are listed for. Next. It's important to remember that even if an exception applies and you do go into a closed session, all of your decisions need to be made in an open session. The only decision really you can make in that closed session is to come out of closed session. So you can talk about things, but you have to come back into an open session before you render a decision. Next. There are different votes that are required for the different closed session exceptions. Some of them require a 2/3 roll call vote of all members of the public body. So what that means is if we have a meeting where we only have 7 members present, because that's a quorum and that's all we need, that's the minimum we need to go forward, we would not be able to go into a closed session for one of these exceptions at that meeting because we wouldn't even have the 2/3 people available. So it's a 2/3 roll call vote of all available members, whether they are present or not. As for the other exceptions, all you need is a majority of the quorum. All votes to go into closed session and all reasons must be entered into the minutes. So next. There needs to be a separate set of minutes that are taken during the closed session, and those minutes cannot be disclosed or released unless there is an order from the court allowing that to happen. And those closed session minutes may be destroyed 1 year and 1 day after the approval of the minutes at which the closed session minutes were approved. Next. So we're going to just kind of speed through the closed session exceptions. You can go into a closed session to consider the dismissal, suspension, or disciplining of an officer. Also, that can include periodic personnel evaluations of an officer or an employee or staff member. You can only do this if the individual requests you go into a closed session. And then the person that requests it can rescind that request at any time if you do go into closed session. So remember, you do not have to go into a closed session, and you only can go into a closed session if the person you're going into the closed session to talk about has requested it. That does not require a 2/3 vote. Next. This one doesn't apply to us, so next. You can go into a closed session for strategy and negotiating sessions with regard to collective bargaining if either party requests it. So if the union requests it, you can go in, but you don't have to. If you want to go in and the union doesn't, it's too bad for the union, you can go in. Next. You can go into closed session to consider the purchase or lease of real property up until the time an option to purchase or lease is obtained. This is because obviously if we had to discuss what we were interested in buying before we, or in the open, the price would probably go up before we were able to actually do anything about it. So next. You may consult with your attorney regarding trial or settlement strategy as long as there is specific pending litigation. This does not apply if there's only been threatened litigation. It does not apply to go into closed session for any other reason with your attorney. This one, though, does require a 2/3 vote. So if there is an actual pending case you need to discuss, you can go into closed session to do so with your attorney. Next. You may go into closed session to consider the contents of an application, but only if the candidate requests that the app remain confidential. But it's very important that all interviews are done in an open meeting. Next. This one doesn't apply, but I think it's funny. Partisan caucuses of the state legislature get to go into closed session. They don't even need to give a reason. Next. You can go into closed session to discuss material that's exempt from discussion or disclosure by state or federal statute. This is a situation where you can go into closed session with your attorney for a non-litigation purpose, so long as your attorney has written you a legal opinion on the matter to be discussed, because attorney-client privileged matters, legal opinions, are exempted from disclosure under FOIA. You can also go into a closed session and discuss any other types of material that would be excluded from regular public disclosure, such as HIPAA and things of that nature. If you wanted to discuss emergency safety plans, cybersecurity plans, things of that nature, you can go into closed session to discuss that because you don't want that material out in the public. Next. As mentioned, you need to keep that separate set of minutes that show the date, time, place, members present, members absent, any decisions, and the purpose for which that closed session was held. The minutes must include all the roll call votes taken at the meeting. Next. Any corrections, as you know, must take place at your next meeting. Next. You must make your minutes available to the public. Next, they need to be available to the public within 8 business days after the meeting where they were made. That's the draft. And then within 5 days after the meeting where they're approved, you have to make the final approved version available. Next. Shall not include information in your minutes that, if released, would prevent you from complying with the Family Educational Rights and Privacy Act. That's something that rarely is ever going to apply to us here for the full board. So next. We've already discussed this, so next. Decisions are presumed to be valid and adopted in compliance with the Act, but if anyone wants to challenge it, and by anyone, I mean any person, they may file a civil action in the circuit court to challenge your decisions. Next. A decision may be invalidated if it was not made in a place available to the general public, if all persons were not allowed to attend, or they were prevented from being able to record, if the decision was not at an open meeting, or if the deliberations were not done at an open meeting, and you didn't have a valid reason for a closed session. Next. So if you don't give a proper notice, you can be invalidated. But if your non-compliance for something such as notice is simply that you didn't include the proper address, but all of the other information is there, the court's generally going to be okay with that, because they're going to say that your non-compliance was minimal and did not, quote, impair the rights of the public, end quote. So for the most part, the little minor technical violations aren't usually going to be enough to invalidate. It's got to be something significant, like the deliberations took place in private by email or text, things like that, or you actually made the decision outside of a public meeting, or there was no notice provided whatsoever. Next. The limitations for invalidation is 60 days from when the minutes are approved. Next. Except in cases where it involves the approval of contracts. Next. All invalidation claims must be filed in Oakland County because that's where we reside. Next. One of the things, if someone is challenging or there's a consideration that maybe a decision was not made properly, you can do a reenactment. So at the very next meeting, you can redo the vote, redo the deliberations, and make sure everything is done properly this time. And if you do that, it doesn't count as an admission against you, even if a lawsuit's already been filed. But the reenacted decision only becomes effective, obviously, from the date of the new decision. But that will generally clear up any claim that there was any claim for invalidation. Next. If you're not complying with the act, then someone may file an action for an injunction to compel compliance with the act. Next. This is a pretty high bar. Again, venue is in Oakland County if someone wanted to challenge us for not complying with the act. Next. Same thing, an action for mandamus is essentially the same thing as an action for an injunction. It's where they are demanding that you comply or carry out a duty you're obligated to do. That has to be filed in the Court of Appeals, but very rarely is that invoked. Next. A claim for injunctive relief is only successful if they actually obtain an injunction. And if they obtain an injunction, they shall recover their actual attorney's fees and court costs necessary to get that injunction. That can be very expensive. But obtaining an injunction is very unlikely. But for a long time, for about 25 years actually, the courts had held that you didn't need to actually obtain an injunction in order to obtain attorney's fees. They said that if they found that there was a violation, so they declared a violation, they said getting that declaratory relief, even though no injunction was issued, was sufficient to entitle the person suing to attorney's fees. And so that was a very expensive time period for public bodies that violated the Open Meetings Act. Even when it would be just a simple technical violation, they could still be on the hook for significant attorney's fees. In 2015, the Michigan Supreme Court overruled all those prior cases and said, no, you actually have to get an injunction. So since that time, claims for injunctive relief have kind of fallen off. Next slide. So here's where we get to what people have been doing now that they generally don't get injunctive relief claims. There's not as much of a market, so to speak, for the plaintiff's attorneys that are suing the municipalities. Next, we have this thing called intentional violations. So intentional violations have two parts as a member of a public body, and this only applies to the actual board members. If you intentionally violate the act, you are guilty of a misdemeanor. That's a $1,000 fine. If you intentionally violate a second time during your same term of office, you get a $2,000 fine and you could go to jail for a year. Next. The intentional violations also include civil liability with a $500 exemplary damage and court costs and actual attorney's fees. So what people have been doing that are suing is, while they may add a claim for injunctive relief, they know that there's not much of a likelihood of obtaining injunctive relief. They specifically name the individual board members and make a claim for an intentional violation. And if you're found to have intentionally violated, it puts the whole agency at risk of a pretty significant award. Next. And that's because the only real defense to an intentional violation, aside from proving that there was no violation, is that you have to assert ignorance of the law. That essentially, I didn't know, I couldn't have known that what I was doing violated the Open Meetings Act. And that's a really, really high bar, particularly if it's something that is very clear within the statute. Like if we, as a board, someone makes a motion to go into closed session to conduct interviews, yet we know the statute explicitly says you must conduct interviews in an open session. It's going to be difficult to establish that, subject that you did not know what you were doing violated the Open Meetings Act. So that's the thing that people have been adding a lot to our cases. Next. The only good thing about the intentional violation thing is that if you are going to intentionally violate, get them all done in one meeting, because you can only be sued for that one meeting, regardless of how many times you intentionally violated. I say that in jest, you shouldn't intentionally violate ever, but if all of the alleged intentional violations occur at one meeting, then you're not going to be subject to multiple suits for the same meeting. Next. That's it. I'm open now to any questions that anybody has. So if not, I thank you for your time.
Andy, this is Steve Taub. It's more of a comment. Outside this president's executive order, the Board of Commissioners, who appoints each of us to the board, has a rule that only in-person participation is allowed. So after the governor's executive order runs out, I think we'll be back under the Board of Commissioners rules. And unless they want to change their rules, we would not be able to do virtual meetings.
Well, we are a separate authority. Now, their rules, is that for per diem purposes? So they don't even allow their commissioners to attend virtually just to listen?
This is not a rule for the Board of Commissioners. It's a rule for our board.
Oh, okay.
When we get our letter saying that we've been appointed, it also says you may not participate by telephone or TV. You have to be there in person. It has nothing to do with per diem. It's just the conditions we're appointed are appointed are requiring in-person participation. Now, I don't know after the governor's order expires or whenever that is, whether they'll still allow it, but if they go back to their old rules, we're appointed only to serve in person.
Well, I haven't looked at the enabling resolution in a while. So, I mean, that in order for that to be applicable legally to us, to the OCHN, it would have to be part of what was included within the enabling resolution. Otherwise, that couldn't be like a new condition. So I don't know how long that's been a condition.
I've been on the board 17 years, and it's been there. It's been every 3 years when I've been renewed.
Right.
I've gotten a letter that says that. I don't know what their enabling resolution was, because that was long before that. Judy
Right.
knows.
I know that we had looked at it well, probably about 5 or 6 months ago, but I don't remember looking at it for that purpose, so I'd have to go back and look again.
Andy, if maybe you could do that and just give yours, and based on, I mean, I think Steve's point is very well taken, and,
right.
But maybe you could take a look at it from a professional legal perspective and say, actually you guys could do this or something, or you cannot do it, and then we'll know, and then we'll have it on record.
Yes, sir.
Hey, Andrew, this is John Paul.
Hi, sir.
Hi. So I have just a kind of a question scenario type thing here, and just listening to what you were mentioning about email and reply all and all those kinds of things. What about a scenario where, let's say there's a point of information you're making to the board, but you're not necessarily across replying or anything like that. It's just one point of information to the entire board from one board member. Is that in compliance with Open Meetings Act, or how would that apply? So one board member sends it to all the board members, but it doesn't start a dialogue or an engagement. Right. Right. Yeah. So like one of the things that I learned was that like to blind CC if you must do that, right? So nobody makes the mistake of replying all or anything, and it's just as a point of information. Is that in compliance? Yeah. No. So I don't have a particular problem with that. As long as you're doing the blind CC, so then you can't get the reply all. I mean, sharing information is different than getting into the back and forth. And that's what needs to be prevented. So that's why I usually recommend that it's not even a board member that does the blind CC to everybody. Usually, like the executive director or the secretary sends out the information. So then the reply, even though it's blind CC'd to everyone, the reply then only goes back to someone that's not even a board member. And then from a practice standpoint, one thing you could do is maybe summarize or include all of those comments that were returned back, and then provide that in advance of the next meeting for discussion at the following meeting. And that way you're not all deliberating back and forth and you don't see what everybody else has to say beforehand, or at least you're not engaging back and forth beforehand. You see it and then you talk about it at the next meeting. Okay. Does that make sense? Thank you. Yeah, thank you. But yeah, blind CC when it's going to the full board is highly recommended.
Anyone else have any questions for Andrew? If not, we appreciate your time, Andy. Okay. That was very helpful, I think, for everyone.
Thank you. Everyone be safe. I'm going to log off now unless anybody needs anything else from me.
All right. Thank you.
Yep.
Okay, moving on. The next agenda item is budget amendment number 1 with Anya.
Okay. So as you guys recall, I have talked to you a bit about how when we do our budget, it's very early in the year. We don't typically have rates or anything like that. This year has been particularly challenging with the revenue delays from the department. So we're finally ready to do budget amendment number 1. So I will walk you through it tonight. We can discuss tonight. It will be an approval item for the board meeting next week. So the document that will come next after I walk through this one will show several adjustments. It'll show an increase to revenue by 1.9% from our original projection. That contains a couple of things. The eligibility trend has increased significantly over the last few months, and we expect that to continue for the remainder of the fiscal year. We did have that rate adjustment in April, and that had an increase on the budget as well. We are expecting roughly $2.8 million in direct care wage increases for the time period of April through June. And then we did have the general fund increase due from COVID, which was about $230,000. A couple of adjustments to grant revenue. We've spoken about the grants in the last few board meetings related to some of them just expired or didn't get renewed. We had the one clubhouse grant that because we weren't able to spend the full $1 million, they did go ahead and adjust that so that they could utilize that money in other places, and they just kept us with what we thought we could spend. We were able to adjust tenant revenue. So the leases had been signed now, and CHN moved in, and now we have ACHC coming on board and those types of things. So all in all, that's an increase to revenue of about $5.5 million. Next slide. So as it relates to expenses, so we did adjust the expense for, we do a reconciliation to how services look once we get into the year, because when we do these are very much projections. So after first quarter, so after December, we look at how things are going, and we make adjustments related to increases in eligibility trends of how many people are being served, how much service is being provided. And so that was adjusted back in February. We did have an increase to the crisis and acute care budget for hospitalizations. And we did see an increase in the MORC children's waiver expense and the SUD expense based on the number of people being served. The direct care wage distribution is expected to be $2.7 million. So in total, the expenses increased by 2.1 because there's a couple of things netting in there. And the change in net assets is projected to be a surplus of just under $3 million. Next slide, please. Oh, you should have budget documents there. I apologize for that. So the budget documents were included in your packet. Hopefully you have that handy, but we'll walk through this very quickly again prior to me requesting approval. And you can ask any questions both either now or then as well. So does anyone have any questions before we move on? No? Okay.
I think it's good news on the increase in revenue.
Yep, and so we will likely do another budget amendment prior to the year end because the eligibility trend is the downside of a recession, or the upside of a recession for us is that we get more money. So we'll adjust that again. I do have some residential adjustments to make later in the fiscal year as well, but this is the information we were able to quantify at this point, and we really wanted to get budget amendment 1 done. So if there are no questions, we can move on.
Okay. Diana?
All right, so what I have and I'm bringing to you today is a contract and agreement review for CDW. We pay CDW each year for our Microsoft Enterprise agreement. Previously, before I started, what we did was we had lots of different licenses with Microsoft, and we bought them with different vendors. So it might be we have to license servers, we have to license our database server, we have to license our computers, Office, all of those types of things. So we never knew exactly how much we owed, when they were due up for renewal, those types of things. So when we made the move to Microsoft 365, We also decided to move into an enterprise agreement so that we would pay for our 365 licenses as well as all of the other licensing that I just mentioned. So we consolidated it. Enterprise agreements are for 3 years. Prior to this, we had just went under the assumption because it was always budgeted. We didn't bring it to you, but now with how we're bringing everything to you, whether it's budgeted or not, that's over $100,000, I'm bringing this forward to you now. So we are going into our 3rd year. And then next year, we will enter into an enterprise agreement for another 3 years. As I mentioned, we had 2 options. We could go into the enterprise agreement, or we could continue to do everything piecemeal. From a management standpoint, it made sense to consolidate. It also made sense to consolidate because our pricing is locked in for 3 years. And if you have to get new licenses, we're able to spread those costs over 3 years. The other reason why we moved to 365, and when you look at this cost, it is an expected expenditure of almost $270,000. That is 365. Once again, all those licenses that we talked about, we are no longer using iDashboards. Well, we technically are, but we're phasing out iDashboards because we've moved to Power BI. And then we've also moved our phone system to 365. We've actually been able to see a hard savings annually of $90,000. I'm sorry, I actually said we had budgeted $270,000 and our expenditure is $212,000. Are there any questions?
I have one, Diana. It's Melchiah.
Yep.
I don't remember when you first rolled out the 365 to us. Did we vote on this contract?
So you voted on, that's a great question, and you voted on that project in the 365 expenditure. What we saw was because we've changed licenses to incorporate Power BI in the phones, and that first amount that I brought forward to you, it did not have the server licenses, the Windows licenses. So every single computer that has Windows on it, we have to pay a license fee for that. Every single server we have has to have a server license, and the same thing for our database services. So when I brought that forward, what would that have been, maybe 2 years ago, 3 years ago? It did not have those costs for those other things in it.
Okay, so is this an action item for us at the board meeting?
It is. Yep. So I will be requesting next week for you to approve the expenditure of $212,000 and some change.
Thank you.
You're welcome.
Any other questions for Diana?
Yes, Pat. This is Jonathan. Diana, is that amount is per year, correct?
That is correct. And we're expecting it to stabilize now because we have made all the adjustments we think at this point that we need to make. And then the only way that this amount will go up is for some reason if we needed to buy new servers, or for every new employee that we have come on, there are some costs. But I expect for this to stay around the $200-ish to $215,000 for the foreseeable future per year.
So you said if we have to buy servers, so this is not all cloud-based, this contract?
Nope. So back to our cloud is a portion of it. And then what we did, because it used to be all of our licenses that we had for, let's say, our computers, what we would do is we would go buy 5 licenses from CDW. We would buy 5 licenses from another company called SHI. We would get 5 licenses from somebody else. When we entered into the EA agreement, we moved all of those other licenses into this agreement. So 365 is only one component of that $212,000.
Okay, so it's more than just the Microsoft enterprise licenses.
For 365, that is correct.
Yeah. Okay. Did we use any third parties to help us negotiate and get the rates down?
So that's a great question. And what we actually do is we use the state of Michigan's My Deal for our licensing cost. So typically another vendors, like the pricing tends to be the same off of My Deal because those prices are negotiated at the state level. And those will be any on the street pricing.
Okay, so the pricing we have comes from state
My
of
Deal.
Michigan's.
Yep.
My Deal. Okay, cool. That's all.
I
Appreciate
will
it.
make a note to remember to put that in there next time, Jonathan, and for any other ones that I bring forward.
That's good that you do that. Any other questions for Diana? If not, we'll move on to Anya again. Talk about another contract. Anya?
Yep. So for those of you guys that recall, with the departure of one of my staff about 18 months ago, I think, going on 2 years, right before state reporting, we brought on a consultant. You guys have seen him and interacted with him, Richard Carpenter. So he helped us work through state reporting and also was on contract to help us revise state reporting and restructure our general ledger and help with our accounts payable process to create efficiencies. So he's been contracted with us for gosh, it must be the full 18 months now or just shy of that. So this contract does start quite a while ago. And when I stepped in after Annette left, he took on some of my additional CFO roles and some of the backfill just to help make sure that nothing was getting behind from my team's perspective. And so I'm looking at getting ready to transition him out. So just because this contract over the life of the contract is over $100,000, I bring it to the board for approval, and I'm intending to extend it to 3/31 of 20. I'm adjusting the contract so that through August,
Anya, I think you meant 3/31 of 21, right?
Oh, I did.
Yeah, okay.
Yep, sorry about that. I'm looking at my update sheet, which actually may have the wrong date in it. 3/31 of 21. Pat is correct. So in August, he'll drop down to just hourly as needed, but he will be finalizing all of the projects he's working on between now and then. And once he is dropping down towards the hourly rate, we plan to post the position that was vacated or something of the like, so that then I can be back to full capacity from a staffing perspective. So this is to extend his contract till 3/31 and adjust the not to exceed to be able to cover that. Let me pull up for really quick the document that has the not to exceed. So this contract started back in 2018 and extends through 3/31. The not to exceed changes to, bear with me, actually $312,000 for that entire period. So this will be a action item for the board meeting, but I can go over any questions or anything you have now.
Pat, I have a question for Anya.
Go ahead.
All right, thank you. It's Jonathan. So you've got Rich working for us through next year, so another 9 months. Although it's declining in terms of hours. So your plan is, if I understand this, is to then post a position come next year spring, so in 9 months, or do you plan on posting a position, let's say in the fall at the end of the fiscal year, hoping to fill someone?
No, so So what I'm planning to do is get that position filled prior to him totally stepping back. So he is contracted 1 day a week basically through August 31st. And so I need to have that position filled prior to then so he can do the transition. And once he does that transition, then he can move to hourly just as needed, because we intend to be fully at staffing capacity, and I won't need him. He'll have his projects done and that kind of stuff. So I will get that position filled prior to then, but I do have plenty of wiggle room in the budget because my salary and that vacant director position currently covers his cost, no problem.
Okay. What's his, you said that he's going to go to hourly. What's his utilization right now?
Well, so now he doesn't work hourly because that would be too expensive. He has a flat fee for the month. So when he was doing 2 days a week, it was one amount. I thought I included the amendment in the board packet. If not, we can make sure to get that to you. He has the fee for his current month where he's doing 2 days a week plus any additional help we need. He's now dropped to 1 day a week to finish up these projects, and then he'll drop to hourly.
Okay. Thank you.
Yep. Oh, Sheila says I did include the agenda or the amendment, so you can look at it specifically.
Yeah, that was in the package.
Yep.
Any other questions for Anya regarding this contract?
Nope.
Okay.
Thank you.
Let's move on to Patrick on a building update.
Okay, hello, can you hear me?
Yes.
Okay, so I'm providing the building update. Let me see if I can click on my photo here. Okay, so the purpose of this building update, as you know, I've been providing this ongoing monthly update on the property for the building up for potential tenants and the status of capital improvements. The board has obviously requested this review monthly, and I want to update as of today or as of June the 2nd. OCHN has received bid documents from Friedman in order to satisfy our procurement policy. They gave us bid documents. They have contractors ready to start on the build out of the ACHC lease, and that's the completion of the 3rd floor. That would be the additional build out space to complete the 3rd floor. And as a result of that build out, we were able to save 6% from the original, as a result of the competitive bid, actually, they were able to save 6% from the original cost that they gave us. And so it's a 6,826 square feet build out. It's a 15-year lease, and the move-in date is October 1st, 2020. So we're all set to go. I believe they're ready to start. We just want to make sure that we have board approval, and I believe Anya may make this an approval item as well, because it is a contract over 100,000, and obviously we've been updating you on this project, and it's here now, and we just want to make sure we have approval to move forward. And I'm assuming she'll get with you to get that approval agenda done via the next board update. But they are ready to go now. Just so for the record, they're ready to go. Actually, tomorrow they wanted to start the demolition of that space, but we wanted to ensure that we gave the board due diligence up front, transparency, so you'll know that this project is getting ready to take place. It is over 100,000, and we do need your approval to proceed.
So Patrick, can I just jump in real quick?
Yeah.
So I think we can probably either add that to the board agenda if there's time for next week, and have it, if we have that contract ready. Is the contract and scope ready?
Yes, since Friedman already been doing our build out, they're going to provide us with the additional change order contract for us to sign, and it
Okay.
will have the dollar amount included on that.
Okay, so if we have that ready to go, we can get that out with the board packet, and so it can be reviewed. And as those it would be 3 contracts that will be up for approval at the board meeting, as opposed to the 2 that we just had. Thanks. Sorry for interrupting.
Okay, thank you for the clarification. And so we're happy to know that they're ready to get started. Hopefully, after we get approval, we can proceed with that build out. And they're looking to take occupancy October 1st, 2020. We're still waiting for a signed lease from tenant number 2. Tenant number 2's broker provided lease comments, and they actually redlined our original lease in order to revisit some of the comments. We had a conference call, and right now our attorney is looking at the lease in order to ensure that some of the red line items are acceptable terms for us that we agree with. Just so you know, this tenant number 2 is the first time that we've entered into agreement or a lease with an outside entity outside of our network. And so it was further conversation. They weren't quite familiar with all the way we do our contracts. And so it was just some minor items that we need to fix, and hopefully we can have this lease signed this week. That's our plan. That's what we're anticipating. So we're hopeful about that. Also, that's a 7.5-year lease. The move-in date is September 1st, but we can adjust that based on when the lease is signed. We also want to mention that our new broker, Mason Capitani, is working on marketing plans to lease out the remaining 22,000 square feet. So the new marketing sign has been installed since the last time we talked and the last time we updated you back in May. So we want to move on to capital improvements. The second phase of the parking lot rehab has been completed. It started actually May 28th. ASI was our contractor. They completed all the repairs and paved the entire lot. We're waiting for them to complete the concrete collars around the drains. That's the last item to be done. That should be done. I thought it would be done by today, but it'll be done this week. That's the concrete collars that goes around the drains. So other than that, everything is paved. They have some more striping to do when they come out. They looked at the plan and they striped it. They didn't stripe the plan properly, but that's minor. They are going to fix that when they come back out. We did complete the HVAC controls upgrade that we mentioned last time. The repairs and startup, all is complete, and we filled the compressors with Freon. And the people that's been visiting the building already noticed a vast difference in the temperature and as the winterization and the summarizing of the HVAC system was successful. We actually can control the HVACs better with this new upgrade. Also, material has been ordered to start the upgrade for the parking lot lighting from HID to LED. So hopefully they'll start that real soon. They've already ordered the material, and looking forward to that as well. And so with that, as I mentioned earlier, ACHC, we was able to save about 6%, which took the build out cost down from $285,000 to $267,000. And that was a result of our competitive bid process. So it worked in our favor, and we're thankful for the $18,000 savings. That's our update for our building. Are there any questions?
I think it's a very good update, Patrick. I do have one question. This is Pat. How are they marketing the open space other than putting a sign out?
Well, we're meeting with Capitani. We're setting up a meeting for this week. We've been in conversation, and he wants to present his marketing plan with us. and I'll get more details on the marketing plan. Right now, we were trying to close out all of the current build outs and plans with our current realtor, and he is working on it. He does have something devised, but we haven't met in order to ensure that what he has completed is satisfactory and something that we like and would move forward with.
Okay.
But it is
This is
something.
Hadat.
Go ahead.
Oh, I'm sorry. Go ahead, and then I'll ask my question.
No, I was done.
So it's probably a question more for Anya regarding the attorney that's looking at what this particular tenant have redlined so much of our lease. Do we pay our attorney hourly, or is it just one fee for the year? How does that work?
We pay them hourly. I think we contract with a couple of different companies, and we utilize the expertise of whatever individual attorney at the time, but we pay them hourly. We don't pay them on a flat fee. That's another RFP that will be happening in the future at some point.
Yeah. So regarding the lease, when you have a type of lease like this, it's a little different than, not every general attorney knows how to negotiate a real estate lease. And this is really more fine tuning. What they're asking for is real estate questioning. And I think we need to give our attorney some guidance on I don't know how that's working.
So that's why that's why we have the firm, and then we are able to utilize the different people in the firm based on our needs. So the attorney we're using in this particular case is familiar on real estate leases and things like that.
Okay. All right. And then before they agree to anything, they'll run it by you because
they don't.
Wondering.
Yeah. So typically they would review it, and they don't communicate with the broker directly. Our attorney communicates with us and us only. So if attorneys need to talk, we might be on the phone, but we would definitely have our attorney communicate with us their thoughts, and then we would make the decision on what we are willing to agree to and what we're not.
Okay, because they had requested for the attorneys to talk to each other, and I didn't think that made a lot of sense.
If that happens, what would happen is just that the attorneys would talk, and then our attorney would come back and talk to us.
Yeah. So I don't think you're going to get a lot of these, but just so that, there should be a limitation to the time allotted. I don't know what the hourly fee is for this particular deal, just because they basically rewrote the lease. So I don't know. That's just something to consider. Yeah. I mentioned it to Pat. I just wanted to bring it up.
Okay.
And we did consider that, and we are conscious of the hours spent on a lease, and we're looking at that closely.
Okay, sounds great. Thank you.
Any other questions or comments? Okay, well, I think we can move, Patrick, we can move on to the budget and finance overview of you and Eddie Brown.
Okay. Okay, so we're going to provide the budget and finance overview. As you can see in our in the organizational chart, I report to Anya Eliason. Also, in that reporting structure, there are several staff that report to me. Those include five accounts payable staff, and then there's two accountants and an accounting manager, which is Eddie Brown. And then we have a facility manager and 3 staff that report to Mark Duguid, for a total of 12 staff members. There's an additional 8 members that report directly to Anya in our budget and finance department. We did want to mention that I have Eddie Brown. He's going to share in this in this presentation, and he's going to assist me in this 5th slide and the 6th slide, and he's going to continue for the next 4 slides, and then I'll pick up after that.
Okay, hello. So here is where we wanted to, talk and show where the budget and finance area failed and in regards to our annual plan that we submit every 3 years, I believe it is, to the board. And so within the budget and finance area, the 2 strategic goals, plan goals that we would fall in would be the administration and operations and the budget and finance area. Next slide. And so the funding sources for the budget and finance area, and pretty much mostly of all of OCHN administrative, the funding would be mostly Medicaid dollars and, Healthy Michigan. I listed SUD Community Block Grant because we do have certain individuals that part of their workload includes the reporting and working with that block grant. And so portions of their time is being allocated to that grant. But for the most portion of our grants, none of it is really being expensed to salaries, with the exception of this one. Most of the grants are service or, expenses for the providers and so forth. Next slide. And so the roles and responsibilities for the staff that Patrick, as he mentioned earlier, there are accountants, accounts, payables, and building and facilities. And where the accountants, that's where I, work directly with the 2 individuals and ensuring the daily operations and monthly reporting and so forth is done. And so here are some of the examples of what, why, how, when. And so the responsibilities, and this is not an exhaustive list of what the accountants do, but we just wanted to give a brief oversight of some of the key duties. One of those being the processing of all providers and / vendor payments. The AP staff quite naturally are the individuals that set up the bills, receive the invoices and so forth. But when the check or the EFT is actually being processed and sent out the door, those are the accountants who are handling that. They also monthly record the journal entries that are required. There are a list of journal entries that we have to post in order to be in compliance with the rules such as GAAP, the GASB standards, and many other uniform guidance and so forth, in order to make sure that we have accounted for the transactions and that they're being accounted for appropriately. And so by them doing their monthly duties of recording these journal entries in financial transaction, and when I say financial, it can be things such as various bank transactions that get processed. For instance, some of our provider cost settlements might be sent to us via EFT versus being, or ACH versus being a check that we received in the mail. But still, in order for that transaction to get captured in our system, someone would have to go and get that detail and post it within our transactions. And so I work closely with the 2 accountants in ensuring that everything has been captured, is being recorded correctly, and then that gives us the opportunity to be able to run the monthly financial statements that are presented monthly to the board. And then another thing that the accountants are responsible for, they work closely with the cost analysts and many others within the organization to maintain and keep up the budget amendments and annual budgets. And also even the audits, which we are still in the midst of our audit right now, hoping before June 30th, which is the final due date of our single audit report. But we work closely with the auditors in gathering the information that they're requesting for their testing and sampling and so forth. And then also there are several grants. I don't know the exact number. Jen, she handles much of this. I think we're anywhere from probably 15 to 20 grants that we have on hand right now, but she is responsible for overseeing the monthly grant reporting, the submission of the FSRs to the state within egrams, and ensuring that we are getting reimbursed for those dollars that are being spent. And so quite naturally, we're doing all of this to ensure the operations are being accounted for appropriately, but also the real truth of it is we're working with an organization to help individuals, and the finances needs has to be there, and they have to be appropriated correctly. And so by ensuring these duties are done accurately each month, that those help ensure that the people are served. And so how the expertise of our staff, the two staff that we have on board, Jen has been there a few years now. We have one temp accountant, two staff, which we're hoping that will be a permanent position. But they're great at the job that they do. They're really in the trenches, ensuring that things are being captured and reported. I'm just kind of the back person, kind of looking high level. So I really depend on them. And throughout the day, we're doing these duties and so forth. And that's pretty much it. Next slide. Accounts payable. Patrick, did you want me to speak to this, or?
Okay, I can pick up the accounts payable.
Okay.
So the examples of the accounts payable, we process encounter data, adjudicate and approve claims for payment. We also, the receipt of invoices from vendors, we process those and prepare processing for payment. And so all the encounter data that goes directly through Odin is what we process. We take that data and we adjudicate it, meaning we approve, and then we also approve it to vouch to verify that those charges and encounters are validated, and then we approve the claim processing, and we put it on the smart sheets and send it for approval. We also do receipt of the invoices from vendors and prepare processing for payment. Usually the analysts provide us with some detail of the vendor payments as well as provider payments. My staff consists of Connie Pulaski. She usually does the hospital encounters. She processed most of the hospital transactions and payables. And then she's been here about 10 years. And then we have Janet Selberg. She's the senior AP processing person. She's been with us about 15 years. And then we have Leanne, Cassandra, and Roger. They all were added as a result of adding the specialized residential function to our organization. And so a lot of the adult foster cares have manual, some of them have manual mailed in claims forms. We process those manually as well. And so the other thing we do is, we receive checks, we process those, we deposit them. We process payables for electronic funds transfers. We do credit card reconciliations. And also right now we're processing about 500 transactions per month based on the average that we do is about 500 transactions of payables per month. Why do we do it? We do it because we want to ensure that funds are distributed to providers and vendors timely and accurately. We have 5 specialists who assist us in doing this process. They do it daily in order to compile the encounter data, to adjudicate it and approval. Usually it takes several days in order to run a check run or EFT run. It's a lot of prep work that goes into processing claims data. The next thing we want to do, and then once this is done, I approve a lot of the payments, as well as most all payments go through Anya, our CFO, for ultimate approval for all payments. That's an update on our accounts payable. The next slide, please. So the next entity is within our organization department is facilities. Mark Duguid, he oversees our facilities. He's the manager for facilities. It includes the daily operations of our building, which includes housekeeping, building maintenance, safety, security, shipping, receiving. And so we ensure that we have a safe building, it's clean, and we contract with an outside contractor that does the cleaning, but we do have an on-site staff that does cleaning during the day to ensure that we maintain a safe and a clean facility for guests and visitors and for staff and for people we serve. The facility department consists of 4 staff. Mark Duguid is the manager. We have 1 facility specialist, Fred Osbrook, and we have another 2 facility attendants, Julian Trexer, and then also Will. So there's 4 facility staff, and they're doing a good job. We have a big building to maintain, and they're doing a good job. The next thing, the facility department consists of 4 people. We just mentioned them, and we want to keep and maintain our building. We have basically a 12-hour day for the most part. They get there at 7 o'clock in the morning, and some of our, with additional tenants, a lot of them are requesting facility support up to 7 o'clock at night. Although we are 24/7 operation, we have staff on call that takes calls outside of the regular 7 a.m. to 7 p.m. hours when required. And also they maintain the RCC building as well. They're on call there. They show up to the RCC building and provide facility support at that building as well. We engage in contracts with build outs. As you know, we have to act as project managers on the OCHN side in order to ensure that build outs and the tenant relationship, we act as the tenant, or we have tenants, so we're acting as the building manager. And so we have the tenants that we have to ensure that they're communicated with and they're getting all the updated information regarding the lease agreement and the operational agreement, and we ensure that we inform them on changes as they occur. And that is done through our facility manager. He interacts with different vendors in order to make sure that our vendor contracts are overseen, and the oversight is there to make sure that they're compliant with what we agree to. And so we work with realtors to broker deals to ensure that our building is operating fully at full capacity. And so those are some of the things that we do in facilities. A lot more things I could mention because but those are some of the main highlighted items that I wanted to mention. And so with that being said, persons served, how do we impact persons served? We're responsible. Accounting practices ensure that funding is available for valuable services, delivery to valued people. And so we ensure that we're good stewards of funding to ensure that we're providing, entering into the best contracts and providing the best value-added services that we can. And then the last item is the system impact on the statewide. Our CFO, Anya Eliason, has and continue to be engaged in all conversation at the state level regarding funding. She's a fierce advocate for appropriate support of public mental health services in Oakland County and throughout Michigan. And so with that being said, I think I covered a general summary, overall view of some of the things we do on the budget and finance side of operations that I oversee and manage. But there's other area of budget and finance that I didn't cover, but this is what, based on the org chart of the titles that report to me. And so I'm open for questions if there are any, but that's the overall update that we have on our budget and finance presentation.
Pat, I have a question, Melchiah.
Yes.
Patrick, at one point, the company that handled our maintenance was a company comprised of persons with lived experience. Is that still the case? Or no?
You said that the company that provided our maintenance was what?
People with lived experience.
I believe that's true. We never changed contractors. So
okay.
If that was the case, they still maintain the contract.
Okay, wonderful. Thank you.
Still maintain the contract. Yeah, that is correct.
I just want to add to that, Melchiah. One of the things we did with the last RFP for janitorial services was we ended up, it was less expensive for us to hire one of the people that actually worked for the contractor. So now we staff one of them as a staff person at OCHN, but we still ended up going with the same company and they were fine with that.
Kudos. Thank you.
Any other questions for Patrick? I think that was a great review. Appreciate that, Patrick and Eddie. Good job.
Thank you, Patrick. All right.
A lot of Patrick. Okay, let's turn to other business. Does anybody have something to bring up? I'm not seeing anything and not hearing anything, so I guess we'll move to public comment. Christine?
Actually, hi, Pat, it's Suzanne again.
Oh, okay, I'm sorry. I apologize.
That's okay. No worries. We did have one comment in the chat, and it was from Lois Schulman, and she inquired as to who is ACHC with regards to our new building tenant. So customer service will respond to her inquiry. And that's all.
Okay, thank you.
You're welcome.
Okay, I think we're board member comments. Sheila, can you go around to the board and get comments about tonight's meeting?
Sure. Dr. Guadalupe.
Thank you. No, I just want to say I thought tonight was very informative. I thought it was helpful to have Andy back to talk to us and remind us of Open Meetings Act and all the information from Patrick and Eddie was very informative and helpful, so thank you. And just a reminder that tomorrow the CEO search committee is getting together to start to look at contract development for our candidates. So that information is posted on the website for anyone that wants to join in and listen to our meeting tomorrow. So thank you to all the committee members for reviewing the information and preparing for tomorrow. Thank you.
Dr. Hans?
Yes, again, very informative meeting, especially the refresher on Open Meetings Act in this age of internet conferences and whatever is going on in the world. I think that refresher was timely and very informative. Thank you.
Mr. Lindemeyer?
Good evening. I think the topic that I wanted to talk about is just throughout my career, I've always advocated for equal pay for equal work. And so while we're doing the negotiations on the CEO compensation, I just want to make sure that we are following the principles of equal pay for equal work. We're making a contract offer to a very qualified woman. Women get paid much less for the same work often than men do, and I just want to make sure that we are following all equal work or equal pay for equal work principles. Thank you.
Ms. Newman?
Hello, everybody. It was a very informative meeting. It never ceases to amaze me how many moving parts go on to that have to be in place just to get the work done. And I want to commend the staff on the exemplary job that they've been doing for us over this COVID situation. I couldn't be more prouder of what we've seen and what we've heard. I also would like to make a brief announcement as part of my community outreach commitments through our contract with OCHN. I'm part of the Healthy Pontiac We Can Coalition, and I'm what they call a community champion. We're looking for people that live in the city of Pontiac, work in the city of Pontiac, that want to share their health journey with the rest of the city. And when we first started having those conversations, most of the health conversations were physical health care, but I have been bringing up the need for balance and the need to discuss the mental health care of Pontiac residents as well. So out of that has come a webinar series that we're doing. Is called Surviving Grief and Loss During COVID-19. I'm co-hosting it along with a young lady by the name of Tashina Gonzalez, who is a health and wellness educator. Her company is Vid Activa Educational Services, and she does holistic work around mental health and well-being. And the current opening session is airing on the Healthy Pontiac Facebook page. And I also sent the link to Christine Burke, and she said that she would be posting that to OCHN's Facebook page as well. It's a series. The next 4 series, we're going to be talking about what grief and loss is, and it's scheduled to air around June 18th. Then the next in the series is how do you manage grief and loss? That's scheduled to air around July 2nd, and we'll also be touching on Minority Mental Health Awareness Month. The next segment is how do you support someone else that's experiencing grief and loss, and that's scheduled to air around July 16th. And then the last segment, airing July 30th, is Discovering the Hero in you. My team has been working with the hero theme for quite some time, but I noticed that the emphasis on the essential workers sometimes leave out others. And it's my contention that every one of us are essential. If we're not in place doing our part, doing what is necessary for us to keep our world moving in a positive direction, then there's something missing there. So that last segment is a tribute to all of us, survivors of COVID-19, survivors of what's going on in our world right now concerning the upheaval around racial justice and equality. There are a lot of heroes out there, and we just want everyone to know how special and how important you are as an individual, that your input and your accomplishments do matter. And if you're not in place doing what you do, then the rest of us suffer. So I just want to encourage everyone to look out for that, tune into it. We're very proud of it. And with that, I'll say good night, be safe, and be well.
Thank you. Ms. Namie Dyer.
Yes, this was, as everybody has been saying, this was really informative. I'm really enjoying all of these first few meetings that I've been a part of so that I can learn a lot more about everything that goes on with this board. So thank you for all of the presentations. I also wanted to just say thank you for the moment of silence that we had at the beginning of the meeting. I thought that that was really important to do and very well thought through. And I really appreciated the statement that was released last week as well. So thank you for that. And also just want to say, as the state continues to reopen, I hope that everybody continues to stay safe and continues to socially distance and stay home as much as possible so that we can continue to flatten that curve. Thank you.
Ms. Bernard. If you're still on, I don't think the mic is turned on.
Hi, can you hear me now?
Yep.
Hello? Okay, fabulous. Well, thank you, everybody. I really appreciated this meeting, particularly Patrick, your presentation and the whole budget and finance department's presentation. I appreciated that very much. Also, I agree completely with each board member. Thank you for your thoughts. And I too appreciated and really liked and respected the beginning of the meeting where we thought about the memory of George Floyd and everything that's going on right now. So everybody stay healthy, think positive. I think we're at a time where, you know, we can really tip the scale so that positive change can take place in this country. So thank you, and that's about it for me.
Mr. Furman.
I just wanted to echo again, thank you very much, OCHN staff, particularly the staff that made the presentations tonight, Patrick, Eddie, Diana, and also thank you for the anti-racism statement again earlier last week, as well as the moment of silence. Have a good evening.
Dr. Todd.
The presentations were great, and I know we're getting used to the COVID-19, all the extra work that that's creating. I know it's a moving target, and I really appreciate the extra effort and risk that our awesome staff is still putting in. And I know we got a long way to go. Everybody stay safe.
Mr. Torres. Mr. Torres, if you-
negotiations. Oh, can you hear me? Can you hear
Yep,
me?
we can. Yeah, we can now. Go ahead.
Okay. Yeah. Sorry, I'm on my phone. And this kind of goes to my other thing is, I know I'll be happy once we're able to start having some formation of meetings. I think all of us have our frustrations with technology and how great it is that we've been able to stay interconnected. But, you know, obviously I think we realize that it's not perfect. So I had to call back on my phone because I think my internet connection went out or something here at the house. But the equal pay in our contract negotiations, I think, is an important aspect to look at. I really enjoyed the Open Meetings Act presentation and all of that information and how it's applicable to the current situation with COVID-19 and all of these online meetings that we're having. Yep, that's it. Thank you.
Thank you. And Mr. Landsman, I believe he had to leave, but I just want to make sure he's didn't sign back in. Mr. Landsman? Okay, I think we can proceed. Ms. Summers?
I, like everyone else, appreciated all the effort that went into the information and the preparation of that information that gave us such a good picture of where we are operationally. And I also have to say that that 8-minute and 46-second opportunity to reflect was quite important for me because it allowed me to kind of reflect again on what it is that I would like to see and do. And it makes me want to listen better and work harder and to actually be a part of the change that I want to see.
Thank you. I just want to make sure I got Dr. Hans.
Dr. Hans made her comments before I made mine.
Yeah, okay. I had her marked, but I didn't. Mr. Kemp?
Well, I think everybody's covered what I would have said. I appreciate getting the opportunity to facilitate this meeting. It makes it pretty easy when you have outstanding people giving presentations. And I think we picked up a lot of good information today. It's good to see the finances are improving. And you know, we can continue doing the great stuff that the staff is doing. That's it. So is that all the board comments, Sheila?
Yeah, that's correct.
You saved me for last.
Pat, would it be okay to confirm that the meeting tomorrow of the search committee is at noon?
Correct.
Okay, just to make sure everybody who might be still with us is sure of that. Thank you.
Okay, I think with that, I can adjourn the meeting. Thank you.
Way to go, Pat. Have a good night.
Nice job.
Good job for you. Good job for your first. Good night, everybody. Good job, Pat.
Good night.
Good night.
Good night.